Florida just got a lot tougher on DUI offenders, even if it's your first offense. I'm attorney Danny Izquierdo of the Izquierdo Law Firm, and with the passing of Trenton's law in Florida as of October 1st, 2025, even first-time DUI offenders can face enhanced penalties, including having additional charges brought against them. Let's talk about this for a minute. In Florida, you used to be able to refuse a breathalyzer if it was your first ever refusal. The only thing that would be used against you would be evidence of your refusal. That means if your case went to trial, a jury would be able to hear that you were offered a breath test and that you refused. There is no additional charge. There's no additional penalty per se, even though some prosecutors' offices would in fact make the offer a little more strict. The conditions would definitely go up and it could be treated as enhanceable, but there is nothing official on the books that would make your first refusal a crime. It was only a crime to refuse a second and subsequent time when arrested for DUI. However, under Trenton's law, as of October 1st, 2025, in Florida, even a first refusal is being charged as a separate crime. The only difference is if it's a second or subsequent refusal, you will be charged with a first-degree misdemeanor. That means the penalties potentially could be up to 1 year in jail. If it's your first DUI and you're being charged with refusal as a result of that DUI arrest, under Trenton's law, you will now be charged with a second-degree misdemeanor, meaning that the maximum penalty is only 60 days in jail. However, this new law is further evidence that Florida is treating DUI cases and DUI offenders a lot more harshly than they previously did. If you've made it through this whole video, you're probably wondering, well, should I still refuse a breath test now that it's an additional crime? And I'm going to give you the greatest lawyer answer of all time. And that answer is, it really depends. It depends on the specific facts and circumstances of your case. Generally speaking, the refusal, even though it's now coming as a new crime or an additional charge, you typically, by refusing, you're not giving the government or the state evidence that they can use against you. Get help immediately. Remember, in Florida, you only have 10 days to save your license by going to the DMV and either requesting hardship reinstatement, known as eligibility review, or challenging the suspension by way of a formal review hearing. Do your homework, find the right DUI lawyer for your case, call them, and let them get started on protecting your rights as soon as possible.